Okay, here we go. Good.
Well, welcome everybody to this edition of ScaleUp Mastermind, the January edition. Just to give you a quick run through of who we are and what we do, we create ecosystems for entrepreneurs. We have a number of different resources through the CBNI. Can everybody see my presentation here? Okay, I'll take that as a yes. So we do scale up business training, business coaching. We train businesses on how to better business plan through our BEST program, our Business Enterprise Startup Training Program. And for fresh entrepreneurs, we provide intro to business. Inspire is a conference also for fresh entrepreneurs. And Let's Talk Business brings relevant speakers to you on a bi-weekly basis. We have our Scale Up Business Training Series, which helps you take your business to the next level. With this program here is Scale Up Mastermind, where we bring experts to you and allow you to ask them the questions that are burning at the top of your mind. We want to help bring experts to you. Our next mastermind will be Mickey Peak with Pacific Northwest BNI, and she's going to be presenting on the art of networking. So mark that on your calendars as well. We also host a number of organizations such as the SBDC, and Jennifer Dye over at the SBDC is available for coaching, and their services are also free. Great program there. SCORE provides mentorship-based coaching. So rather than coaching on very technical projects, SCORE will give you industry experience. Our PTAC organization helps businesses connect with government contracting and navigate that sometimes confusing process. Hopefully we'll be able to, if you've got some questions about that, kind of pick Jessica's brain a little bit in terms of what we can provide in that direction. The Lacey Makerspace is a place for entrepreneurs, but also for inventors to help kind of catalyze the design process and get it worked out so they can take it to market. And our Think Network is a local investment group that provides investments into businesses that have the need for more capital. So no maximum dollar amount there, and it's entirely up to them what they invest in, but we're going to help you present your case the best to them so that if you are having trouble getting commercial lending, that perhaps this is an alternative that you can expand your business upon. Additionally, if you've got any COVID-19 impacts or have questions about the grants that have been coming through, and it's a nonstop PPP, EIDL questions, or where perhaps you can find resources, we have our business hotline here as well that is staffed from 9:30 to 3:30 every weekday. So these are the different organizations and partners that we partner with the Center for Business and Innovation. And with that, I'd like to introduce us to our featured speaker, Jessica Jensen. She is the principal at Capital City Law, and she will be presenting today on legal essentials for businesses. So hopefully this will provide our attendees with some valuable insight. So
Great.
take it away, Jessica.
Well, hi, everybody, and welcome, and thanks for being here. I'm going to do a little screen share here with my PowerPoint, just so we can get that going. All right, share, there we go. There we go. So I'd like to do this a little differently than perhaps some of your others have been. I'd like to go through my slides, and then I really want to open it up for what are their burning questions. There's always things that come up in every business. And I'm going to talk about the 5 things that I think you might want to, that you should know in business. I've been doing law for 40 years now as an attorney and paralegal. And I love what I do. And I've worked with a lot of businesses from starting to being ongoing, love small businesses, and we love to help businesses grow. The thing that I find is most troublesome to me and to the other attorneys here is when we are asked to help fix a problem that could have been prevented. So my first point out of the gate is please, please, please get your legal team together, get your accounting team, what I call your business team. So let's talk about who your business team is. You don't need all of us all the time, but you want to identify early who is your business team. Your business team includes people like the Center for Business and Innovation. It includes your business consultant. It includes your accountant, your bookkeeper, your lawyer, your insurance agent. These are typically the people that I recommend for your business team. Might also include a business coach. There might be some others that are nuanced for your industry. If you're, for example, a restaurant, you might have some other types of consultants that would be specific to your industry. So identify your business team and keep them informed. Do it early, at least make the introduction. So when an issue comes up, you won't be lost and making a decision that later we have to fix. So with that said, I'd like to start with 5 things that you should know about, and I can give you a little bit of guidance on why I think they're important. The first one is contracts. There was a time when we could do contracts by handshake, and still there are times when you don't need a written contract in place. Generally speaking, though, if you are providing goods or services, you want a contract, generally speaking. So you want to have a solid contract. And yes, you can pull something offline. I've seen a lot of really horrible contracts pulled offline that don't apply to a particular business. So if you are going to do that, understand your contract. Don't just pull something offline and hope that it's good. Read it, understand it. And if you want to work with a lawyer, which I encourage, have your lawyer draft your contract specific to your industry. You do not want a generic contract. So for example, if you are doing work as a consultant, you want a consultant contract. If you are doing work as a mental health counselor, you need a mental health counselor contract. They're very different animals. And so you'd like to have something that reflects what your work is. There are some key provisions I always want to see in a contract. One of them is, what's your clear scope of work? The second one is, I want to see in a contract that there is a provision for what happens if you have a dispute. I'd like to see you go through mediation or some other process that will keep you out of court and resolve the dispute with the least amount of angst and expense. The third thing I'd like to see is a legal fees provision. If you do end up in court, I want you to be able to get your legal fees back. And generally the rule is it's got to be mutual. I'd also like to see you have something in your contracts that say who's responsible for what. So indemnification, I'm only going to be responsible for what I'm responsible for. I'm not taking on your responsibility. Those are some examples of having a good solid contract. The idea with a contract is that you have a verbal agreement of what you're going to do, and that contract will never be used, ideally. Ideally, you won't ever need it. But if you need it, you're going to be very grateful that you have it. If there's any kind of a question, always, 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 it goes back to what is in your contract. I mentioned the importance of understanding your own contracts. I run into clients who have contracts and have provisions in them that either don't apply to their business or that they have no idea what it means. So the classics are things like indemnification. If you're not sure, you can certainly do a Wikipedia and figure out what does that mean, or talk with your attorney, learn about what does indemnification mean? What is a hold harmless? What does it mean, force majeure, force majeure? What are those types of provisions? Do I need one in my contract? There's so much great information available on the internet as research. If you do your research ahead of time, when you meet with your attorney, you are then going to be well more educated, and then it will cost you less because you have a clue. Please don't tell your attorney how to do his or her job. That's our job to figure out how to do it for you. But it's helpful for me to have a client who comes in with a general idea of this is what I do, this is what I know I need to include, help me do the rest. And then I have something to work with. Another point is to read everyone else's contracts. Just don't willy-nilly sign contracts, especially the ones that we get online. Now, that said, we're using a Zoom today, I think. You know, with Zoom, you're going to read that contract and you're going to sign it because it's a take it or leave it. Take it or leave it. If you want the Zoom, accounts, you're going to sign their contract. We all have those types of things. But if, for example, you've hired someone to do work for you, read their contract, make sure you understand it. And honestly, if there's something that doesn't make sense, that's probably not you, it's probably the contract. So ask, and if you don't like it, ask to have it rewritten if it's not clear. So those are my key points on contracts. I'm going to move on to leases, and we can ask questions as we go. Does anyone have any burning questions on contracts? Okay. I'm going to move on to leases. And this is another example of where if you have a commercial lease, you're leasing property somewhere, you want to, before you get into that lease, read your lease and understand it. You want to look for the hidden costs. It's not that they're necessarily being hidden on purpose. It just may be that you don't understand what those hidden costs are, and so you miscalculate what your expenses are. For example, let's say that your contract, your lease says that you are responsible for maintenance. Well, what is that? Is it maintenance of the HVAC? The HVAC system can be exceedingly expensive to maintain and repair. So many leases say that the tenant will be responsible for maintenance and repair of all systems. And then your HVAC goes out and that could cost thousands of dollars to fix. That's negotiable. So go back and understand those types of things. Look for your hidden costs in leases. Landlords, if you're leasing to someone else, you want to make sure you spell that out. And ideally, in the interest of full disclosure, you want to make sure that your tenant understands what they're getting into. You also, if you are leasing property and the landlord is going to do tenant improvements, you want to be very clear about what those improvements are, when are they going to be made, and who is going to pay for them. So for example, you move into a building and the landlord is doing certain improvements and you're doing others. Does the landlord need to approve what you want to do, or do you get to do whatever you want? Usually the landlord requires approval. And maybe the landlord is doing certain work. Well, you want it spelled out what they're going to do. You don't want to rely on a handshake, because a handshake is not binding, it's not enforceable. And so you need to have it in writing and clearly spelled out. So if the landlord is going to put in a restroom, for example, an ADA restroom, it needs to say an ADA compliant restroom, and to include whatever fixtures you expect to have in there. That, because if it's not specified, it could be a situation where you have the restroom, but there's no fixtures in there. That's an example of where you want to be clear about what are you expecting, when is it going to be done, and who is going to pay for what. Another thing I look for in leases is a mutual indemnification provision. So I'll tell you, I get a lease to review for a client, and right off the bat, I look for three things. I look for the indemnification provision and to see if it's mutual. If it's mutual, then I know that it's generally a fairly balanced lease, meaning it's fair to both parties. If I see an indemnification provision that is all one-sided, that the landlord wants the tenant to indemnify them for everything, then that tells me that the lease is one-sided and I need to review that lease exceedingly carefully, because there's other things that are buried in there that will impact my client. So look for the indemnification. What does that mean? I want to know that my client, the tenant, is responsible for the tenant's own negligent and intentional acts. I want the landlord to be responsible for their negligent and intentional acts. And if I get sued because of something the landlord did, I want to know that my client is protected. If my client gets sued, my client will be protected because the landlord will indemnify, meaning say I'm responsible for, and the landlord will pay the legal fees for me if I get sued. So I want to be ensured that I'm not going to be responsible for something the landlord does. And the last thing about a lease is personal guarantees. Many times to get into a leased building, you have to sign a guarantee, meaning the owner has to personally say, I'm going to guarantee that if I don't pay, that you get to come after me personally, even though I have an LLC or a corporation. Be very cautious in agreeing to that because it's essentially putting the lease in your name. And along those same lines, when you are starting a business, especially if you're getting a lease in place, make sure that the lease is in the name of your entity, not in your name. Because again, if it's in your name and it's a 5-year lease, and if for some reason the space doesn't work out or you want to get out of it for any reason, you are personally on the hook for the entire lease payment for 5 years. There are some exceptions, but generally speaking, that is the worst case scenario. You could be held responsible for the whole thing. So a personal guarantee is generally saying that, okay, I've got my business is leasing this for 5 years, and I'm agreeing that for the next 5 years, I'll also guarantee that if my business goes under, I'll pay this lease. You can negotiate that. You can actually say, how about a 1 year or a 2 year? Let me show you that I'm a good tenant and that I pay on time. And then you won't need a personal guarantee from me. Any questions about leases before I move on? Okay.
Yeah. How do you come across somebody who is unwilling to lease to a new organization, for instance? So let's say you filed your articles of incorporation. The business hasn't been around for a bit. You've got that concept, right? You've got a little bit of cash that you've donated to your business, but the landlord is still looking. How often do you see landlords unwilling to allow organizations to rent?
Mm-hmm. Generally, the landlord will let you do it, but you'll have to either be on the lease you generally will have to personally guarantee it. So that personal guarantee essentially means you'll step in and pay whatever the tenant doesn't pay. So let's say I'm a new tenant, new business. I've got my corporation or my LLC. I'm ready to go. And now I've got my landlord, and the landlord gives me a lease in the business name, but the landlord wants a personal guarantee. That's how the landlord gets protection. So most of the time, a savvy landlord will lend to a new business, but they will want a personal guarantee. So then the question is, well, how long should I lease for? If you have any questions at all about whether your business will be successful, do a short-term lease. Let's talk about that. You can do a lease for 2 years with the right to renew for 3 more. Rather than doing a 5-year lease, I recommend a new business lease for 1 year or 2 at the most, with including in your lease the right to renew for 3 or more years, or 5, an additional 5 years, because then you know that your business is, by the 1st, 2nd, 3rd year, you have a general idea that your business is going to be successful, that it's the right location, that you have the right space that you need. And so at that point, you're done with the lease in 2 years. So you're limiting your liability from 5 years to 2 years. And you could even do year to year. I'll do it for 1 year with the right to renew for 2 or 3 single year lease terms. The landlord will generally be open to that. And you can negotiate that personal guarantee after the 1st year. So if you do a 1-year lease to show, let me show you that I can do this and that I've got the ability to pay this lease, I'm going to sign a personal guarantee for 1 year, but if I renew, I don't want to have to do a personal guarantee. You can negotiate that.
Would you purchase an insurance policy, kind of like a business interruption for that gap piece?
That's a different issue. We're going to talk about insurance a little bit, but that's not really a gap business interruption. Yeah.
It's something like that. I mean, I wonder if there's a coverage for that, because
I don't think so.
There's a market for it.
Yeah, there should be, but there really isn't. We'll talk about that when we get to risk. So thank you. Good question, Valerie. Okay, so I'm going to move on to intellectual property. Most people don't realize that they have intellectual property. So we're going to talk about identifying it and protecting it. So for example, your content on your website, or perhaps on your Facebook page where you have written articles or a blog or something, that is intellectual property. You need to identify, think about all the things that you do, handouts that you might give to your clients, documents that you might create, logos, anything you might do, depending on the nature of your work. Look and identify, do you have anything that you created that you are sharing with your customers or your clients? If you do, that is probably your intellectual property. And the way to think about it also is to say, if somebody else took this and used that, would I be okay with that, or would I be upset that they didn't ask me? So if you don't want someone to share it without acknowledging that it's yours or without paying you for it, then it's intellectual property, and you want to identify it and you want to protect it. So how do you protect it? Well, if it is written documents, written like a blog or something written, it's a copyright. You can very easily protect that through the copyright laws by just basically copywriting it. And you can copyright it online, very simple. That's one way to do it. It can be an expense if you're doing a lot of blogs, if you're doing a blog a week or something. You may not want to do that. What you can do is also put your the little C symbol, the copyright symbol at the bottom. And I can give you some language. It's essentially copyright, your name, comma, all right, your year, the year, copyright like 2021, Jessica Jensen, all rights reserved. That at least puts, and then save that someplace. Nowadays, for example, our websites are usually saved so that you could go back and find when you first started using something on a blog or a website. But that's an example of how you can do a copyright that we call a common law copyright. It's not as good as getting it registered with the feds, but the US Copyright Office, but it is a good thing that you can do, and it does provide some protection for your intellectual property. Another example would be you have you've created something, like you've created a logo, or you've created for your business, trademark. You've created a product, that would be a patent. So if you're not sure about this and you think you have something that might need to be protected, the idea is to identify what it is and then figure out how to protect it. And again, this is a bigger conversation. I wanted to just really try to get some ideas out there for you to think about in your own business that you may not be aware of. And then that's something you definitely want to discuss with an attorney. And probably the folks at the Center for Business and Innovation can help with some basic information on that as well, and how to copyright things and where do you go for help on that. And am I correct, James, that we have a patent attorney who comes down periodically or does Zoom calls periodically with some of our participants in the Center for Business and Innovation? Am I right about that?
That has been a resource in the past.
Yeah.
And I believe that we will be continuing that in the future.
Great, good. All right. Any questions about intellectual property? Okay. The next topic is risk management. This is where Valerie's question comes in. And risk management is such a strange concept, but it's the idea of identifying the risks in your business. Every business has risks. And the risk could be something simple like the risk of not getting paid. And so you want to identify your risks, manage them, and if you can insure against loss, that's great. So we're going to talk about some classic kinds of risks. Okay, one of them is liability. You have a risk if you have a place of business, even if it's your home, someone coming to see you in your home, someone coming to see you in your place of business, they trip over a carpet on your front walkway or in your front step and fall and break a leg. That's a risk that could happen. And if it does happen, the key is, what are you going to do about it? We're going to talk about insurance and why we would have insurance. So that's one risk. Then your business, doing the kind of business you do, makes a difference. So for example, I'm a lawyer. I have professional liability. If I give bad advice to a client, I could be held responsible for that. So I've got to identify that. That's a risk. So in my office, and for example, I have a risk that someone will trip and fall on my front walkway if it's icy. I have a risk that I or one of my attorneys could screw up and give bad advice. Those are two risks. So by ignoring them, I don't have the ability to manage or insure. But identifying what our risks are, then I have the ability to do something about it. And every business has risks. So you're walking, maybe you're a dog walking business, or maybe you are a therapist, or maybe your business is being some kind of a consultant, or you're selling a product. Products can have risks as well. For example, your product fails, there's a risk of customers coming back and saying your product failed, or a risk that your product creates harm to someone. So there's multiple risks depending on what you're doing. So with every business, you have to identify what are your risks. Now the question comes, how do you manage it? So I can manage my risk at my front walkway, for example, by ensuring that when it's icy out, that we put salt or some kind of de-icer down so that my clients don't slip on the walkway, right? I can also manage it by warning people. You've been to restaurants where you walk in and there's the big yellow warning signs that say, warning, wet floor. Why are they doing that? They are managing a risk. They have a duty to warn you about a risk, and they're managing it by telling you that don't walk here because it's slippery. You're going to fall and you're going to hurt yourself. That gives them a defense if you do fall and hurt yourself. I told you that it was slippery. What are you doing going in that room? Okay. And
We do
then,
have a question
go ahead.
for
Yes.
Valerie when there's a good point to.
Yeah. We're coming up with the concept of insuring. Once you can identify how to manage your risk, then you can look at, can I insure against this risk? So for example, building insurance, having commercial general insurance allows you to manage the risk of someone getting hurt on your premises. It's pretty low risk in my office, but for some of you, you might have very high risk workplaces. Maybe you bring customers out onto a work floor and they could get injured by a flying piece of wood or something like that, you know, whatever it is. The nature of what you operate. Maybe you operate a business where you have customers coming in to use your equipment. That could be risky. So you look at, can I insure against this risk? So in my world, for example, I have commercial general insurance that insures my building. So if something happens on the premises, either I or my staff get hurt, then there's some insurance that might cover that. And then I also have professional liability coverage that covers if I make a mistake. I or my attorneys make mistakes in our work. Not every business is able to get coverage, second type of coverage for the work they do. So a contractor, for example, has insurance for their work, but it does not cover defective workmanship. It doesn't cover what they did wrong. All it covers is if they damage someone's property. So I'm doing a new roof for your house, right? And I'm up on the roof, and now I accidentally drop my hammer on your car, and it smashes through your car window. You know, I've got the hammer up there. I'm hammering, fixing something up there on the roof. My hammer drops out, drops into the front windshield of your car, and now I've damaged your car. That would be covered by my insurance because I damaged your property in doing my work, but it doesn't cover the fact that I screwed up putting the roof on. Okay. So those are some examples of the type of insurance. Now, Valerie was asking, what do you do about the gap? Like, for example, if you're a restaurant that has interrupted service because of COVID, you might well have an insurance policy that covers the lost income. Some of you who are in business should check your insurance policies to see if you do have lost interruption and see whether it's covered. Not all interruption coverage will cover your business losses, but they might. Theft. You have an employee who steals from you. That might be covered by your policy. Ideally, you manage that. So you have a store, and you manage that by having good controls over who has access to the cash register or the the online accounts, but then you find out that your staff are secretly copying down numbers and running them through somebody else's system and taking client credit cards, taking customer credit cards, that might or might not be covered by your insurance. You've got to look at that. But insurance can help with this. And insurance, one of the biggest things that most people don't realize about insurance is that it's not so much the damages, meaning what has been lost, it's the defense, it's the providing a legal defense for you. That is typically going to be your biggest expense, because you basically get a lawyer who defends it for you. So if you get sued, your legal team from your insurance company will defend that, and they will help settle that claim because they want to get that claim settled. So that's one of the best reasons to have insurance, if you're able to get insurance for what you do. Okay. So anything on insurance or risk management? Yes, Valerie.
Sorry, I don't want to take us too far off the track.
Yeah.
That's great information. It just gets my head going. So back to professional liability. You're carrying a professional liability policy for you and your attorneys, and somebody wants to file a claim against you. Typically, that would be covered under your insurance. Do you have a provision if they want to file a complaint against you at the bar? Do you have an indemnification that you can use to shift that they can't call the bar and make a complaint unless it is a legitimate?
Yeah, and unfortunately in my profession, we can't do that. Usually you can't preemptively tell people they can't file a complaint against you. Anyone, I know, wouldn't it be nice? Wouldn't it be nice if we could do that? But the idea here is that even if I had that in my contract, they might be able to get that set aside.
Okay.
And would you sign a contract with that in it, saying I'm going to release you from all claims right up front? Yeah, I wouldn't.
No, but I would pause a bit before I filed the claim to really say, is this legitimately a claim, or am I just being cranky?
Now that's something you could perhaps put in there, that if you file a claim against me that turns out not to be legitimate, then I have the right to sue you for my legal fees. I don't think I want to do that as for my clients, you know, from a customer service perspective. And so you remember the risk management concept we talked about? That's how I manage my risk, is by being careful about who my clients are. I don't take those grumpy people, and I get rid of them pretty early. Now, not everybody can do that. If you're a mental health counselor, for example, you take your,
I'm a domestic violence counselor.
Yeah, okay. So
everybody hates me, and
everybody hates you. Yeah, okay, I get it. So I think people are gonna do what they do, and the best thing you can do in your world is to probably develop a thick skin and to have good insurance.
I have really good insurance.
And a thick skin.
Yeah, well, yeah, that goes without saying. You have to do that.
As you know, it's not about you. It's about frustration with the process. Yeah.
Right.
Yeah. Yeah. So yes, I think that would be really hard to uphold in court. Something that preemptively says you can't complain about me. I don't think that would be allowed. Okay, I'm going to move on since we're on the subject of disputes. You have three options, really: negotiate, mediate, or litigate. There is another one called binding arbitration, which I encourage rather than litigation. And so typically my contracts, when I write a contract, I will say that the parties first must participate in mediation before anybody goes to court. And that's assuming that you can't resolve it through just good old-fashioned negotiation of like, how can we get this worked out? And if not, that before you go to court, you mediate. Mediate is way less expensive. I can count on one finger the number of cases that I have had that have not settled through mediation. And I've done countless mediations over my career. Mediation really helps parties get to a solution. Nobody ends up liking the outcome, but that's usually a sign of a good mediated outcome, that everybody walks away happy it's done, not necessarily thrilled with the result, but they can live with it. And the other point of this is that compromise will save you time and money. There's one mediator in town who is a retired judge who says there's an old curse that says, may you be involved in a lawsuit in which you know you are right. That is so true. You can be right and still lose a lawsuit. And so compromising and recognizing what I call this the cost benefit analysis to a business owner. When you look at how much time and money it is going to cost you in litigation, generally it's better to cut your losses and go. So the customer or client who doesn't want to pay you for your services, who wants you to cut his or her, your bill, you did the work for the client, they don't, the customer, and they want to bring a lawsuit against you saying you were defective workmanship, or whatever the issue is. Usually it's better to try to come up with a negotiated or mediated settlement, and to keep in mind that it's better to cut your losses, because every time you spend an hour in a deposition, 2 hours going to a hearing, 3 hours here, a week preparing for trial, 2 weeks preparing for discovery, it's taking you away from your business. So I say, do the cost benefit analysis. What is it going to cost me to fight this person who hasn't paid my bill, versus how much am I going to spend to do it? If it's going to cost more to fight, then it's not worth it. So for example, I have clients come to me and say, this client owes me, this customer or client owes me $5,000. And can you do anything? I said, I can write the lawyer letter. Sure, we can do that. But your better bet is to go to the small claims court, because you're going to be able to handle that yourself. You'll put the time and energy into it, yes, but you'll get a quick result. And given the dollar amount, you will be able to get through that quickly, and you'll get a judgment. If the judge agrees with you, you'll get a judgment that then the other party will either pay, or it will sit there hounding their credit until they pay. So good luck trying to get a car loan or a home loan with that judgment sitting out there. So most people will compromise at that point. And so they say, well, I don't agree to this, but will you take this much? It's cheaper for you to resolve this dispute. Now, I want to say there are times to fight. There are times to stand your ground and fight. I'm not saying don't ever fight, of course not. But generally speaking, when I advise my business clients, it's look at what is it going to cost you to fight. If it's going to cost you $30,000 or $60,000 to fight this litigation, and the issue is $30,000 in dispute, let's find a cheaper way to resolve this. Let's get into mediation, because you're going to spend some money, but not nearly that much, and you might get something at the end. And if you're talking a couple of $100,000 claim, well, now it's worth the 30 or 60 to be litigating. So give some thought to the cost benefit analysis of how it's not just the money and the legal fees, it's also your time away from your business, being distracted by litigation or being distracted by a disgruntled customer. Okay, so those are the 5 things I wanted to cover tonight. And now I'd like to open it up to whatever questions you might have for me about any topic, but on these in particular.
So I had a quick question going back to the lease. So if someone does a personal guarantee on a lease and then their business goes bankrupt, they're still on the hook to pay that lease one way or the other. Is that correct?
Yeah, if the business just goes out of business, and classic example right now, we're seeing it with some businesses that their business is gone, they signed a personal guarantee, and now they're stuck on this. Now there are what we call defenses to contracts. And one of the defenses is impossibility. So if a business was shut down because of COVID, they weren't legally allowed to operate, they might have an out. But this is something that the pandemic is going to generate a whole lot of litigation about, honestly. So your best bet is to look at it and say, well, in that case, do I fight it, or do I try to negotiate getting out of this somehow? Pay something nominal to get out of this, and let the landlord lost as well as I did. Nobody intended this, and so how can I get out of this gracefully and move on? And if the landlord won't cooperate, well then let them sue you and you deal with it. And if worse comes to worse, then you go through business bankruptcy. Like, let's say you're sitting out there on a judgment for $120,000. Go through personal bankruptcy to get rid of that judgment would be one way to handle it. Not ideal, but if you don't have the cash, which most people don't. The one thing I would say, don't default on anything. Really, it's a bad idea, because whenever, I don't care if it's a small claim, do not default. Make sure you show up at a court hearing and make sure you're heard. Because even if you do it on your own, because if you don't, what happens is that you have no control over how much, whatever they're asking for, they get. At least if you can give a judge something to work with. The judges don't want to screw you over, but if you don't show up and defend yourself, they have nothing to work with. And so if the other side comes in asking for 120,000 and you think it's really 60, you really need to go in and go in and plead your case, get something in writing, document it, and go in, and when the time comes, argue it. And ideally hire an attorney to help you through that process.
So Jessica, something that's relevant to the CB&I and myself and some of the programs we're working on is a lot of people are putting together classes online and having different portals, right? And there's all of this data collection legalese that you've got to work through. What are some of the key concepts to understand when dealing with online user agreements?
Some of the key concepts in that, let's see, where to begin with this.
How not to digitally stub your toe.
Yeah, how not to digitally stub your toe. Well, the first thing is when you're doing a webinar or the like, you really want to ensure that you are not using someone else's content. So the reverse of your intellectual property is don't use somebody else's. Number one. Number two, recognize that like doing something like this, whatever I say today is not legal advice, right? On a specific question. You can give your disclaimer. And so that's a helpful thing to do. And the other thing is that if you're putting it out to the world, you can, generally speaking, if you are letting it be reposted, it's public domain. You're not trying to keep anyone else from using it. So someone else might say, wow, this is a cool webinar. I think I'll show it to my junior league group, or I'm going to show it to my chamber group or something like that. If you don't want it to be shared, then the best you can do is share it with your participants, right? And then for a limited period of time. So like for 30 days or 20 days or 10 days. So like, let's say somebody wanted to participate today and could not attend at the last minute. Then what you can do is give it to them for a brief period of time. And once they have listened to it, then it's gone. So you can give limited access if you don't want to have it reposted and reposted. But you can also turn this to your advantage of saying, if you have CB&I plastered all over your marketing materials. So for example, I do other marketing, I do other webinars for other organizations, and they typically will allow some things to be plastered elsewhere because it promotes their brand. So you can use it to promote your brand. And if I do my own webinars and the like, I don't have a problem with it being reshared. I can repost my brand. But because it promotes my brand, and then people in theory will come and look at other things that we might be doing. So you can look at which is more important to you, getting more people in your door to learn more about what you do, or is it more important to you to protect that intellectual property? And if you're working with third parties like myself, this is my intellectual property. I created it. I don't have a problem signing it away. But generally, you're going to want to have anybody who does a webinar for you. So like you have them sign something that says, I agree that I can be recorded. I agree that my information will be shared. I agree that I have a license to use your intellectual property. Pretty straightforward.
Now, furthering on that question, if they come onto your show, right? ScaleUp Mastermind.
Yeah.
Is there any implicit acknowledgement that this is that intellectual property created during the show, for instance, is allowed to be shared.
Intellectual property, you can tell people to share it or not share it.
Okay.
And honestly, I think most people will just share unless they're told that it's copyrighted. And so I would have, if you don't want to be shared, then I'd have a big copyright. You know how in the beginning of a video, you see the big copyright disclosure, this is copyrighted material. Put something up on that at the very beginning, that this is copyrighted material and can't be shared. You've got to give people a warning, not at the beginning, not at the end. Put it up there where they can see it. And that this is copyrighted and is not allowed to be shared. So for example, you're a mastermind group. So if one of your members wants to share something, but they don't want it shared, it should be plastered and everybody should be informed and everybody should agree that this is not going to be shared. And I know that's how masterminds work, that you share information together, but you don't necessarily want it shared with other people, what your financials or your issue is or that kind of thing.
Yeah.
Right.
Well, when you go into a Zoom call like this, they're usually at the front end of it, there's an option to put that kind of disclaimer up and make people check that they read it first. Right.
Right.
Yeah.
Other questions?
Hi, yes. Can you hear me?
Hi, I can hear you.
Okay, great. I'm using these headphones. I didn't know if they had the volume. So you said with the website, so I have blogs and things on my website, and as long as the website's copyrighted, that protects my blog? Or do I need it on my each individual blog?
I would put it on each individual blog.
Okay.
And it's very simple. Just do the same thing your website is protected, but that's arguably that's the framework, not necessarily the content of each page. And if you don't care about it, that's one thing. But if you do care about someone taking and reposting your stuff without your permission or not giving you credit for it, then put it on each page.
Okay.
Yeah.
Thank you.
Yeah. Other questions?
Now, I'll throw one up here. Do you do or cover setting up businesses, whether it's a corp or an LLC or a sole proprietor? And do you do a discussion around that particular topic? And even that might go to you too, James, when you're helping people set up businesses. Do you help them walk through that process?
Yes, I certainly do. My firm does. And my law partner, Nick Milner, does a lot of that. I tend to, at this point in my career, I tend to do the more complex issues. So he'll bring me in if there's something more complex. I do a lot of buy sells. That's something we didn't discuss. Have an exit strategy for your business, but I do a lot of people buying, selling a business, and also succession planning. So, but yes, we all do that here. And when you're looking at setting up a business, and I know that CB&I and the Center for Women in Business have lots of materials on this. And I know years ago I did one on this, and I know other people have. Which structure do you choose? Should you be an LLC or a corporation? My general rule is that if you're going to be a corporation, don't be an LLC and elect the corporate status, unless you don't ever intend to sell your business. If you're going to ever think about selling your business, then be a corporation and form as a corporation, not as an LLC, because eventually you'll have to convert if you want to sell your business.
I mean, what is your succession plan if you want to stop, quit, retire, die, whatever, and when you are an LLC? You have to change it first?
Yeah, you change it to a corporation so you can sell your business. Now, some businesses are suitable. There's a selling of a business and selling of assets.
Mm-hmm.
Some businesses do not have, they don't have a lot of assets. Like I don't even have a lot of assets, tangible assets. Like I don't have a lot of equipment, right? I'm a law firm. But on the other hand, if you are a mechanic shop, or if you are, you have a lot of product, you're a store, retail store, and you have a lot of inventory, then you do have a lot of tangible assets. So you want to identify which do you have. And so I'm really going to go three concepts here. One is, do you have something worth selling? Always, always, always you have something worth selling. But the question is, do you own your business or own a job? If you are in business for yourself, like if you're a counselor, some attorneys they own a job, they don't own a business. They're a sole proprietor, they're never going to grow. That's what they like doing, and they're doing it really well. And they're going to close up shop when they retire or when they decide to no longer do it. That's owning your job, but you still have something worth selling. And the something worth selling is your phone number and your website, because you have a client base over, let's say, 20, 30 years of doing it, right? And that client base will allow you, people will call in. You're getting referrals from people who've referred you from somebody you don't even know, right? Because someone knows you, referred you, and then told another friend about you. So that's what happens after 10, 15 years of being in any business. You get referrals third hand. So that phone number is worth something, and your website is worth something, because that's how people find you. And it's easy enough to then sell those things alone. So don't ever close your shop. You always have something worth selling, almost always, unless you've done something egregious, like you robbed a store and now nobody wants to do business with you, okay? So when you're thinking about your exit strategy, think about, how old do I want to be when I retire? Do I want to grow? Do I want to grow from being like a sole counselor? Or do I want to grow my store to 2 locations? Or do I want to grow my business to franchise status? Whatever it might be, you can think about, how do you monetize that when you're ready to get out? There are people who actually sell businesses. They find buyers for your business. So don't assume that I don't know how to start. Hire a business broker, kind of like a real estate agent. There are people out there who are agents to buy and sell businesses, and they'll find a buyer for you if there's something worth selling. And so if you have your exit strategy, that gives you that goal to work toward of when do I want to retire? And what do I want it to look like? Do I want to fully retire? Do I want to take on a partner in the meantime? How do I want that to look? Okay, so those are some of the things to look at. But back to the question about, does an attorney help you decide what to do about your corporation or LLC? Yes. And it's not just about, at least in our firm, it's not just about, sure, we'll form your LLC. It's about having a consultation. What are you trying to do? Is this the right form for your business? What should we be thinking about? Are you going to have employees? And what are some of the other risks there? And we help you identify what are the risks that you want to manage. Like, are you going to have employees? That's a whole thing completely. If you're going to have employees, we need to be thinking about policies, procedures, perhaps an employee handbook, that kind of thing. Other questions? Okay.
This has been so helpful. I really have enjoyed this.
Well, good. I'm glad.
Everywhere here. Now my head's going really fast.
Well, good. I talk fast, and that's the good news. I get to cover a lot of stuff, but I tend to talk fast. I know that. So I don't have any specific written materials on this. I do have something on contracts. If anybody's interested in that, of things to think about when you're doing your contracts, I can send that along to James, if that would be helpful. I also have something on 10 things every business owner should know, a little different than this, but just kind of bullet, like these are things to think about. I do want to close, because we have a few minutes, with the idea of employees. How many of you have employees? Anybody?
I do.
Yeah, okay. So the one thing I'm going to caution you is that it's great to have employees, love employees, and those of you who have employees know the hassle of the benefit and hassle of employees. In this day and age, if you have employees, you cannot afford to be ignorant about employment law. And so either join one of the wonderful associations, maybe like your trade association that has access to employment information. So like if you are a realtor, there's the Realtors Association will have people who can help with this. If you are a contractor, there's the Contractors Association, have people who they can put you in touch with people who do nothing but advise their industry on these issues. So figure out if there's someone in your industry who can help you, and if not, have your own personal attorney help you with employment issues, hiring, firing, And the key here is you hire slow, check your references, do all the stuff you know you're supposed to do, hire slow, have clear expectations with a position description that clearly states what they're going to do, what their requirements are. And then if it's not working out, fire them within 90 days, let them go. Don't try to make it for cause, just say, but don't make it for any, you've got to have some kind of rationale. Not just, geez, you're not a good fit. Give something that they can work with. Geez, you're not catching on the way that we had hoped you would. You're not getting this, or make it about performance. Do not make it about them personally. Make it about performance. Always, always, always about performance. And do it within 90 days because that can help minimize the risk of your unemployment, a claim against your unemployment rating. So what I mean by that is that if they came from a prior employee and they are let go within 90 days and they file an unemployment claim, it will go against their prior employer, not against you. If it's after 90 days, now you and the prior employee share the cost of that unemployment claim.
All right. Well, thank you so much, Jessica. I'm just going to echo everybody else here and just say that it's been extremely helpful for me. I'm sure them as well. And you know, we love having you as a resource here for the Center for Business and Innovation. I'd also like to let people know that through the CB&I, there are a number of different resources that we have access to. So if you need specific coaching needs, as Jessica mentioned earlier, there are patent attorneys that we work with. She does also provide some services through the CB&I as well, and we have other organizations such as if you were with manufacturing, we work with Impact Washington to help provide you with lean processes and streamline your process. And we can provide individual coaching as well. So at the CB&I, we really do try to provide access to the most relevant resources that we can at little to no cost to the businesses. So with that, I will conclude today's session. If you have any questions or you need to get in touch with, if you want to get in touch with any of the participants or with Jessica, feel free to reach out to me directly. My phone number is 360-464-6051, and you can reach me at jdavis@thurstonedc.com. All right. Thank you, everybody. And
thanks, everybody. Nice to meet you all. Bye.
Bye.